I went there last night with my friends.
We went over and then wouldn't know. Drove up to the lighthouse
Yeah,
in front of the lighthouse. We stopped by there
on the way back.
yeah, like 1 or 2. What is this? And we turned around.
This meeting of the Escambia County Board of Adjustment on February 18, 2026 is hereby called to order with 6 members present. We have a quorum. Now we'll have the swearing in of Travis High and J.C. Cardwell.
Please raise your right hand. Do you, Travis High and J.C. Cardwell, solemnly swear or affirm that you will support, protect, and defend the Constitution and the government of the United States and of the state of Florida, and that you are duly qualified to hold office under the Constitution of the state, and that you will faithfully perform the duties as an Escambia County Board of Adjustment member, so help you God? Thank you.
Will the clerk please swear in the members of staff?
Please raise your right hand. Do you solemnly swear and affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Members of the board, copies of staff's resumes have previously been provided and remain on file for reference. The board has previously recognized staff as expert witnesses. Does anyone have any questions regarding their qualifications and abilities to offer expert testimony?
No.
Seeing the BOA meeting package for February 18, 2026 with the Development Services staff findings of facts have previously been provided to the board members. The chair will now entertain a motion to accept the BOA meeting package into evidence. Do we have a motion?
I'll motion.
Second.
All right. Motion by J.C. Cardwell and second by Ross. All in favor of this motion, please raise your right hand. Motion passes. Seeing none opposed. Do we have proof of publication?
Yes, sir.
Did the publication meet all the requirements?
Yes, sir.
The chair will now entertain a motion to waive the reading of the legal advertisement. Do we have a motion?
I'll make a motion.
Motion by Susan. Do we have a second?
Second.
Second by Ross. All those in favor of the motion, please raise your right hand. All in favor, none opposed. Members of the board, you have reviewed the minutes for the Board of Adjustment meeting held on January 21st, 2026. Upon your review of the minutes, are there any additions, deletions, or corrections? Seeing none. The chair will now entertain a motion regarding the minutes of the Board of Adjustment meeting held on January 21st, 2026. Do we have a motion?
I'll make a motion.
Motion by Susan. Second by, that's Randy. Let's see. All those in favor of the motion, please raise your right hand. All in favor, none opposed. Motion passes. Ross, can you read the purpose of the Board of Adjustment and conduct of meeting, please?
Yes, sir. The Board of Adjustment hears administrative appeals, variances, and conditional use requests. These hearings are quasi-judicial in nature. Quasi-judicial hearings are like evidentiary hearings in a court of law, however less formal. All public testimony will be taken under oath, and anyone testifying before the BOA may be subject to cross-examination. All documents and exhibits that the BOA considers are entered into evidence and made part of the record. The giving of opinion testimony will be limited to experts, and closing arguments will be limited to the evidence in the record. After hearing the testimony and arguments for and against the proposed action, and before making its decision, the BOA will consider the relevant testimony, the exhibits entered into evidence, and the applicable law. Because decisions of the BOA relating to variances, conditional uses, and extensions of development order for site plan approval are final, unless overturned by court of competent jurisdiction, the county may issue development orders and permits for properties in accordance with the decisions of the BOA. However, if applicant requests the issuance of any such order or permit, and such order or permit is issued, the applicant and not the county shall bear any risk that the such decision may be set aside. The development order or permit may be revoked, or the development may be otherwise enjoined by the reviewing court. Any applicant for relief from the decision of the BOA for said actions, or any aggrieved party as defined by state law, may seek review of such decision by filing an appropriate pleading in the court of competent jurisdiction within 30 days of the BOA decision. The date of the BOA decision shall be the date of the BOA voted at the conclusion of the hearing. Whenever the BOA denies an application, no new application for the identical action on the same parcel shall be accepted for consideration within a period of 180 days of the BOA decision. Any person aggrieved by a decision of the BOA relating to an appeal of an administrative decision may, within 15 days thereafter, apply to the circuit court for review. Each individual who wishes to address the board regarding a particular issue must complete a blue request to speak form and submit it to the clerk of board. These forms are located on the table at the back of the commission chambers. You will not be allowed to speak until we receive one of these completed request to speak forms. We must have these completed forms for public record.
Thank you. Ex parte communication, all written or oral communication outside of this hearing with members of the BOA regarding matters under review today are considered ex parte communications. Ex parte communications are presumed prejudicial under Florida law and must be disclosed as provided in Board of County Commission Resolution 96-13 before a decision by this board on any administrative appeal, variance, or conditional use request. The chair would ask, as each case is heard, that any board member who has been involved in any ex parte communication regarding a respective issue to please identify themselves and describe the communication. All right, first case, we have case number CU 2026-04. That's 10040 Pensacola Boulevard, a conditional use request to allow service and repairs of motor vehicles, requested by William Dunaway, agent for MS Prime Transportation, LLC owner. Ex parte communications regarding this case, any knowledge or information obtained from a site visitor or any other source, board members? Seeing none. With the individuals who are a party to this item, please come to the podium and state your name and address for the record so you can be sworn in by the clerk.
Morning, Mr. Chairman. Thank you. Will Dunaway. I represent the applicant in this case.
Good morning.
And Will Dunaway is an attorney and does not need to be sworn.
Okay. Were you provided with a copy of the criteria required to obtain conditional use and a copy of the findings of facts?
Absolutely. Thank you.
Okay. And you do understand all that you received, right?
I do.
Okay. Would you like to make a presentation, or would you like to hear staff's findings at this time?
Right. We would defer to staff's findings, the public, and then we'd be available for any questions or comments and clarifications.
Okay. Thank you, sir. Staff?
All right, good morning, Board. Andrew Holmer, Escambia County Development Services. This is conditional use case 2026-04. Here we have our location map. The site is on the east side of Highway 29, south of 10 Mile Road. Here we have a zoning map showing a 500-foot radius around the site, the parcel outlined in the blue. As you can see, that entire area is either commercial along that block or heavy commercial light industrial. On the west side of the road, we do have some HDMU. Here's a future land use map for the site showing it as commercial. This is a wellhead map showing that it is in a 20-year travel time contour. Here we have an aerial map of the site. And I'm sorry, would you go back to the zoning map for just a second? Thank you. So, Board, I wanted you to know this. There has been an update here. If you'll look to the south, it just says unnamed. There was right-of-way through there, through an older mobile home park. That has since been vacated to the owners that had the property on either side. All right. Here we have the notice of public hearing sign posted on the site. This is looking northeast onto the site to the existing structure. This is looking southeast across the front of the site. Okay. So, as to the findings, again, this site is zoned commercial, and the applicant is seeking conditional use approval to allow heavy truck service on a commercially zoned parcel. Under the commercial zoning district, you can see there, under its conditional uses, we have retail sales that includes service for heavy truck uses. As to the specific criterion, A, compatibility. The subject parcel is located along a major arterial road in an area of mixed commercial and heavy commercial light industrial zoning and uses. While some nearby uses function out of previous residential structures, there are many large service-type structures in the area, and the proposed service facility can be operated in a manner compatible with the surrounding uses along this commercial corridor. B, facilities and services. They are available and will be provided as needed for the proposed use. The connection to these services will be reviewed at the development review stage. C, on-site circulation. Ingress and egress are available via both US Highway 29 and North Palafox Street. Specific connections will be reviewed during the development stage. With Highway 29 being an FDOT road, the specifics of that connection are going to be awaiting what DOT signs off on. FDOT, sorry. D, nuisances and hazards. Commercial zoning will limit the vehicle service to the interior of a building only, which excludes paint and body work or outdoor work and storage. The proposal shouldn't generate nuisance conditions for the adjacent parcels. E, solid waste. Solid waste service must be provided as needed for the proposed use. F, screening and buffering. Screening and buffering will be required between the proposed use and any adjacent residential uses. I would add to that, even though it is commercial zoning, it's the disparity of the uses that is going to be requiring that buffering. G, signs and lighting. Signs and lighting will be evaluated and will be limited to what is allowed by provisions of the LDC. Exterior lighting shall be deflected from adjoining properties and public streets. H, site characteristics. The parcel is entirely within a 20-year time of travel contour to an ECUA well. A wellhead impact report will be required as part of the DRC process, as is standard practice. I, use requirements. Service facilities will be limited to indoors per the requirements of commercial zoning. As to findings, staff recommends approval of the proposed use as requested with the condition of completion of the DRC process and receipt of a development order. That concludes staff's findings.
All right, thank you, staff. Board members, do you have any questions for the staff at this time? Okay, seeing none. All right, would you like to respond to that, Mr. Dunaway, or would you like for the speakers to come forward first?
Thank you, Mr. Chairman. We'd like the speakers to come first, and then we'll rebut and answer any questions.
Yes, sir.
Thank you.
Okay, our first speaker for this case is Adrian Hammond. As you come forward, step to the mic and get sworn in by staff, if you would, sir.
My name is Adrian Hammond. I live at 9735 North Palafox Street, Pensacola, Florida.
Okay. You can go
Please
ahead.
raise your right hand. Do you solemnly swear and affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I did.
Thank you.
I was sort of told I could pretty well say what I wanted to say here, and I didn't have to do one A, B, C, D, 9. Is that right? Huh? I know Horace pretty good. I'd like for you to go back to your map that showed where you were south of the property, where you showed the pictures. You showed a picture of the property, you showed pictures of the property south of it. Why don't you show a picture of the property adjoining it north of it?
It's standard practice. We take a picture of the sign and we take pictures of the property in question. We can show you it on the aerial.
Show it, please.
There you go.
What you have located there north of the property and adjoining this property is a church. We're a small congregation. We're hoping to grow, and we are growing some right now. A church is not compatible in any way, shape, or form to what's being proposed here for this variance. I know one of the things on the they're going to submit here is that we only meet on Sunday. They work through the week. When somebody uses their property, that shouldn't be a reason if it's once a week, once a month, or if it's vacant property, if it affects their property. Allowing this to be permitted is going to be with the variance subject to properties, work on semi-trucks, large storage trailers. Some of the trailers are already there on the back part of I presume it's the back part of this property, already double stacked, and we haven't even got to the zoning yet. If you wanted to go and look at the property and see what's going on there. It will be an eyesore on 29. It'll be an eyesore to us along the north side adjoining this property. If you had a business or an office on the property already built or somewhere that you worked or a church, would you want this property next door, which is going to have semi-trucks parked in it, waiting for maintenance, and undoubtedly we're going to have trailers double stacked adjoining us. It's not going to be very long. You read in finding of fact, as far as commercial zoning is concerned, that outside storage is not allowed. I've been a realtor for 50 plus years. I started very young. I've been a commercial realtor for over 35 years. And I will tell you that this will affect the value of our property. This is presented as a nice new building with a nice new things going on there. It's not going to be long before you can have trucks parked all along there. And I would ask you, if you were here and your property adjoined this property and this type of use, which is a major variance in my opinion, to the zoning of
Thank you, sir.
commercial. This should be HCLI only, and it is not. So I'd ask you to please look at it as from the aspect that the use of this property is not compatible with.
Thank you, sir.
I would caution the board, opinion testimony is limited to those that you have accepted as expert witnesses. So any statements such as affecting my property value, you would need to qualify the witness.
Even if I'm a commercial realtor
Your
for 35 years.
Respectfully, sir, your 3 minutes is up, and we appreciate your concern. We really do. Yes, sir. All right, our next speaker will be Tammy Kirkland. And keep in mind, as you come forward, speakers, you have 3 minutes, and so make sure you get it in the proper time. Tammy, if you would state your name and address and get sworn by the board, please.
I'm Tammy Kirkland. I live at 5115 Barano Park School Road, Molino, Florida 32577.
Please raise your right hand. Do you solemnly swear and affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God? Thank you.
I live in Molino, but I attend the church that's right next door to this. And I do have some concerns. They might be my opinions, which y'all may not consider an opinion. But I do want to clarify some things just so as neighbors we can understand what might happen. So we have some limited information here on the findings and the criteria and things of that nature, which us lay people really don't understand a lot of that term. But just one of them that I would want to get clarification on would be criterion D, the finding of fact about the zoning will limit the vehicle service to the interior of a building only. Okay, vehicle service, that could, can anyone say what that is? Because it excludes paint and body work or outdoor work. So what's the difference gonna go on in the building and what are they gonna do outside?
And while the deputy, my name is Horace Jones, Director for Development Service Department. Those are good questions, and the applicant, when he come, he can basically provide more insight. But the findings, the words, what is there is what is there. If it says limit on the inside of a building, excluding outdoor work and painted body work, that is an exclusion. Period. Straightforward.
It kind of contradicts itself because it's saying it limits the work, vehicle work to inside the building.
Inside of a building,
It
yes.
says it excludes.
Right, because there are certain type of repairs requires outdoor work, outdoor painting. But in this zoning category, with this conditional use approval, it excludes that. Now, we do have other zoning that does allow for that, but this zoning would exclude, and that's a very, very broad definition, and we're gonna follow that. If there's any violation, if it's approved,
Okay.
there are gonna be some consequences behind that.
Okay. My next, I know my 3 minutes are going fast. Explain what type of buffer we're talking about that's gonna go in between our property line and this property? What kind of buffer are we talking about? Is it gonna be a privacy fence, a wood fence? Is it just gonna be a chain link fence? When you say buffer, what do you mean?
So, one of the things about coming for conditional use is this board can impose conditions over and above those required by the code. So, in general, it would be a 6-foot privacy fence supplemented with plantings. This board can impose higher standards than that. So that would be something you would want to address with the board and with the applicant.
Okay. Another concern is, it's my understanding that that property at this time is on septic system. Is that going to remain as it turns into a commercial business?
That will be a discussion that they will have to have with ECUA moving forward. Again, this is within a 20-year travel contour of a well. The ECUA is part of our development review committee, and that is a discussion they will have with them. If sewer is available, ECUA will have them connect.
Okay. Lost my train of thought. Okay. On this picture here, can y'all tell us where the building is going to be in relation to the red outline? Is it going to be right up against our property line, or is it going to be back south?
So, in general, it will need to meet the building setbacks, first of all. Second of all, when they turn in an actual engineered plan, the determination of that, besides the setbacks, is going to be based on vehicle access. Can you get a vehicle in and out? Do you have room to plant your buffering and put in the fence? The turning radius of vehicles factors into that.
And my final concern is, right now at this time frame, we do only have services on Sunday. In the future, that's not to say we could not open a daycare. We could not have daily activities at the church. If there's going to be a daycare with small children, that is not compatible with what's going to go on over here.
And sure, I mean, you could seek that. That would be a conditional use as well, just like this. You would do the same thing they're doing and come to this board and request that.
Mm-hmm. So do they have access to this property from the old highway? It goes all the way through to 29?
So,
little sliver?
Sure, that sliver exists. If you've gone by there and looked at it, it would be quite a challenge for someone to drive,
They've
put
already
a,
got tractor trailers lined up back there on that little sliver.
so what I'm trying to explain is when they turn in engineered plans showing their connections, engineering may require an access. I can't guarantee that. 'Cause what we're talking about today is the use of the land. Can that use be conducted? We don't have the finalized engineered plans.
Does anyone here know who owns those trailers that are already lined up on the property back there? It's almost like they're already moving in.
Do not, I was on the site, I saw the trees. I did not see trailers stacked up.
As of Sunday, they were there. We
Okay.
walked back there. They got to line up all along that property line already. It's like they're already moving in.
That would be, that would definitely be something to reach out to our code enforcement
Right, absolutely.
about.
Absolutely. If, yes, and thank you, Drew, for saying that. If there's any actions that may not be approved or authorized at this time, that is a code enforcement action, not this body.
And
That
who-
is a code enforcement action.
Okay. And back to the daycare and the children possibility, who would that issue go before instead of this group here? Is that for another group?
Right. Right. And this the thing, we cannot, this body, we cannot go on a lot of speculation on what if in future uses, and we do know churches grows just like other business grows. So we can't just try to pinpoint them on something that may happen. We got to deal with what is presented to us and what's going on at the sanctuary at this time. That would not be fair to both parties.
Well, my final concern would be, I would just ask the board to please seriously consider this being next door to our church and what that would do to us. Thank you.
Thank you. Before you leave the mic, and I want to respectfully ask the board, do you have any questions for Ms. Tammy, or and also after Ms. Tammy leaves the mic, if you have any questions for the other speaker, I didn't give that opportunity when he was up. Any questions? No questions? Okay. All right, thank you, Ms. Tammy. All right, any questions for the other speaker?
I do have a question with the attorney.
Okay, yes. Okay, we'll wait till he comes up. Staff, you have any closing statements?
No, sir. We would.
And I would like to ask, again, this is not the end of if it is approved by the board, this is not the end of the process. There's another process that Mr. Will Dunaway been doing this a long time. He knows that, but that's called the site plan review process. And we would get into the specific design criteria of the site, stormwater, fencing, buffering, and in that process, if the boards approve it, if there's any other enhanced buffering requirement, we could. That board can put that on. So I don't want to think that they just come in and do what they want to do. They cannot. They cannot. When it comes to the site plan, they are very, very subject matter experts, and we can make sure that they meet the requirements of the code when it comes, if we issue them a development order and as they proceed to the next level of building the structure. So there will be some other additional, I want to say hurdles, but challenges. This is not the end, if the boards approve of it.
Okay, and also, you can come forward. And as you come forward, staff, I know we have some new members here today. Can you make it very clear on exactly the concern for today? Because sometimes, throughout the process, we hear so much and we read so much, but can you specifically make it clear to the board what we are here for today?
So, again, it's conditional use. These are uses that can be somewhat more intensive than those that are allowed outright in each zoning district. And with this board's approval and any possible conditions you would wish to impose, it can be approved. It's like I said, these uses are sometimes a little more intense, and depending on the neighborhood, sometimes it can be a square peg trying to fit in there. But that's why this process is here. Unlike a variance, this is not based on a unique physical hardship on the land. This is more of a compatibility issue, which is why we stress the buffering requirements and quite often distance requirements. The distance requirements wouldn't matter or wouldn't come in this case, but the buffering does. And again, this will, if it's approved, need to go through development review. And if there's, somebody wishes to challenge it, it will come back to you. So you are making that decision. I would remind you to please base any decision you make on the criteria. And take in testimony that is based on those criteria, because that is the only thing that your staff can address is those criteria. And general statements don't always align with the criteria.
Any questions from the board concerning that?
No, not with what staff said. I did have a question for you, but Horace answered that.
Oh, great.
But for clarity on the record in regards to criterion D and the fencing and the border, just for clarity, if that is supposed to cover or block all view of outside stored vehicles in general, correct? So if it's going to be taller, will the fence or the border need to cover all of that?
So keep in mind, your buffering requirements are to alleviate impacts. We do have a fence height requirement. It is commercial. They could go to 8 feet or higher. There's a limit to how high you can build a fence. So other issues, you're going to have setbacks from that property line. So distance in itself, when you have fencing, factors in to that buffering.
All right, thank you. Mr. Dunaway?
Thank you, Mr. Chairman. Again, Will Dunaway for the applicant. I thank you for your questions and also for staff's presentation. And I did want to clarify, because one of the speakers did continually refer to this as a variance. This is not a variance. This is a conditional use request. Your code, as the staff has laid it out, allows for permitted use in commercial area, and it allows for uses with conditions in that area. And specifically for this use, a conditional use is allowed for utility trailer, heavy truck, and recreational vehicle sales, rental, service, limited to the same restrictions as used automobile sales. So this is a conditional use that is allowed in this zoning area. As you'll recall from the map that you saw, this entire area is commercially zoned. Your future land use is commercial and the zoning is commercial. The church property is in a commercial zoning area, and this property is right in the middle of commercial zoning area. Right now, it has been, it has I would say a falling in house. You'll see that up in the corner, and it's very close to where the church is. You see that structure there? There's also kind of a ratty, that's my term, but it's like a truck or something that's sitting outside. It looks like somebody's selling insurance out of it, but it's weird. Yeah, there it is, a little bus. It's like all of that's going to be gone. This is a redevelopment. The planned application, the plan use is again for heavy, for truck repair inside. There will be a new building that will be built in the middle of the parcel, and I wanted to address that. This is not something that we go through the details of at this area, but buffering has come up, and I want to make sure that you understand our plan, or the applicant's plan, has a single metal building, which will be the shop, where all work is inside that shop, big doors that open, a building for repair of box trucks is what we're talking about, those big Penske moving trucks, those kinds of things. That's where that will be. Planned now on a preliminary site plan would put the thing as the structure right in the middle. So about 105 feet from if you'll put that aerial back up with the church that shows that, yeah. So approximately, if I The idea of the building is to center it as best we can right in the middle. We're looking at, the preliminary site plan now shows us about 105 feet from the boundary line that is adjacent to the church, that is the north boundary line, about 115 feet from the south boundary line, and about 75 feet from, there it is. This is a preliminary, this is a survey, and something that we will go through the permitting process with DRC, as the director indicated. But that is essentially what we're looking at. Again, so that is good buffering. The access, the property is, that's not just an access way to the old highway. That is part of the property. That would be owned in fee. And then back there, if you'll go back to the aerial, I just wanted to point out, there is a huge tower. The staff can help me out, but it's a, in your, yeah, right, aerial, right there in that corner back, right there. So that corner, there is a huge tower, commercial tower structure that is already in that area. Just to the east of North Palafox, huge moving storage areas, warehouses, lots of warehouses. As the south, you see, there were some old trailer parks and those kinds of things. So I think the important point is the staff report is very clear in showing that the applicant has met all of the criteria. And in that way, we would ask for your approval, that being the evidence that is before you. And I'm available for any questions.
Any question from the board? Mr. Dunaway, how can, just curious, say when you have those box trucks, they come in for repairs, even though they'll be being repaired inside the building, what if they come in with a motor leak or transmission leak or a hydraulic leak? Is there any plan that you know that you're aware of as far as keeping things under wraps?
Well, certainly. So I know that the business has to operate in accordance with all of the regulations, both the county regulations, and in that case, if you had a leaking issue, that would be a state case, FDEP. If there were any spill or something like that, that would be would have to be reported to the Florida Department of Environmental Protection. There are criteria for, amounts of, and then that spill has to be immediately remediated. So the plan, which would be part of the operating plan, would be one, not to allow that. Two, if that did occur, to quickly address, report, and correct.
And keep in mind, this isn't a travel time contour from a well, so ECUA is going to require a spill
yeah, as part
plan
of
for that.
As part of the wellhead protection, which we will address during the DRC, which all of the commercial properties in this area, because ECUA has wells throughout the area, there is a specific criteria for that, and everything has to be double. If there were any, they have to be double lined and a quick response process.
And also to Chairman, this is not going to be no salvage yard, no junk yard, not any of those things. The zoning does not allow for it. And again, if it even start going that route, which I know that Mr. Will Dunaway and this client won't do that, there is other protocols in place. Code enforcement will definitely get involved because salvage yards it's a problem. But in this area, I promise you, code enforcement will get involved, which they're not doing that anyway. Different set of rules, different set of protocols, different set of procedures.
Thank you, Mr. Chairman.
Yes, sir. Board members, any further discussion? Okay. Staff, anything else?
No, sir.
Okay. The chair will now entertain a motion regarding the item CU 2026-04. And with your motion, please state whether or not you adopt the staff's findings of fact as presented by staff. If for any reason you do not accept staff findings, please go through all the criteria and address each one specifically as to why you do not concur with the staff findings and provide substitute findings. Do we have a motion?
I'll make a motion that we accept staff's findings.
Okay. Motion by Susan to accept staff's findings. Do we have a second?
Second.
And any further discussion? That's it. Okay. I just want to remind all of you just to keep in mind when we vote, we're here to not vote on our personal feelings, but we're here to vote and do the right thing by law. And sometimes that don't line up with our personal feelings sometimes. But just a reminder. That being said, all in favor? Motion passes. None opposed. All right, our next case. Case number CU-2026-08, 13090 Lillian Highway, a conditional use request to allow accessory structure in the front yard of a waterfront property, requested by Chris E. Johnson and Kelly Z. Johnson, owners. Board, has there been any ex parte communication or any site visits concerning this? Seeing none. Any board member intends to refrain from voting due to a voting conflict of interest? Seeing none. Would the individuals who are a party to this item please come to the podium and state your name and address for the record so you can be sworn in by the clerk?
Yes, I'm Kelly Johnson. The property address is 13090 Lillian Highway, Pensacola.
Please raise your right hand. Do you solemnly swear and affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you.
Good morning, Ms. Kelly Johnson.
How are you?
I'm doing fine. Would you like to hear the staff's findings and then respond, or would you like to go ahead and present your case to the board?
And I'll
first?
defer to the staff findings.
Okay, thank you. Go ahead.
Good morning, board. My name is Melissa Shirley. I'm an urban planner 2 here with Development Services Department. This case today is a conditional use approval to allow an accessory structure within the front yard of a waterfront lot measuring greater than 1 acre. The accessory that is being proposed today, I want to remind the staff there was a recent recent conditional use for a similar request. I want to make it very clear this is an accessory structure, not an accessory dwelling unit. There is a difference between the two. So let me go forward here. So this is the location map. This is the zoning with a 500 radius. This is the future land use. This is the flood zone. And this is an aerial photograph of the subject property. This is looking from Lillian Highway at the property. This is looking east on Lillian Highway. This is looking again from Lillian Highway at the property. This is looking west along Lillian Highway. This is across the street, looking from the property across the street. This is also looking from the property across the street. This is a road. The property spans from Lillian Highway all the way to the water. This is a road that adjoins the property roughly halfway through. And this is looking at essentially their entrance area along Rosarito. And then this is, again, looking at the driveway that they utilize along Rosarito. Okay. Again, as to the findings of fact, here I want to reiterate what the code states here when the parcel is a waterfront lot. Accessory structures can be located in the front yard if the structures are proposed to be at least 60 feet from the front line of the property as granted through a conditional use through the board. The first criterion, general compatibility. It is compatible with the character of the surrounding area. The applicant has submitted already to the board a site plan proposing the structure, the accessory structure, which will be a pole barn / detached garage. It will be essentially 75% of the gross square footage of their existing single-family dwelling, which meets the criteria through the Land Development Code. The second criteria, facility and services, they will utilize the same services as their existing single-family dwelling. As we go on to on-site circulation, this property, again, I mentioned, it spans from Lillian Highway all the way to the water line. They do not, to the best of my ability, access their entrance on Lillian Highway as much as they access through Rosarito Way, which is set back from the road, and it's actually buffered by several other residential housing in that area. There's a dirt road that, again, spans the length of the property that they would use to access not only this proposed accessory structure, but their single-family dwelling. As to criterion D, nuisances and hazards, the use of the structure is in keeping with residential uses. There are no proposed nuisance type generators that are going to come from the use of this accessory structure at this location. As to criterion E, that's solid waste. Again, this based off of what was submitted to our office, they will be using the same method of waste as a single-family structure that is already existing here on the site. As to criterion F, screening and buffering, again, this because it is a residential structure, it does not require any additional buffering. It does, again, sit on the property that spans over an acre from Lillian to the water line and is surrounded by natural vegetation already. As to criterion G, signs and lighting, again, this is a residential structure. There are no proposed signage, and any lighting would need to meet the residential building code here at this location. For criterion H, the site characteristics, some things to note, this property is located in several flood zones. However, the location of this accessory structure will be outside of those flood zones. However, during the permitting process, there may be other criteria that gets reviewed or is required, but that would be handled at time of permitting. Also, based off of the site plan that was submitted to the office by the applicant, it appears that the location of the proposed accessory structure will meet all of the setback requirements for the zoning district. As to criterion I, the use requirements, this will comply with the additional conditional use requirements that are required in the LDC, and I'll just read that excerpt right there. Accessory structures may be located in the front yard of a waterfront lot if the structures are at least 60 feet from the front lot line. And again, if the conditional use is approved at this location, the applicant will need to submit all of the required plans for the permitting process for not only the Development Services Department to review, but also the Building Department. In conclusion, the staff's findings are that the staff recommends approval of the conditional use as it is requested.
All right, thank you. Board, you have any questions for the staff? Okay, you can go ahead. Yes, ma'am.
As we said, we are requesting an accessory in the front yard of our property, and it does, like they've said, go from Lillian Highway all the way to the bay. It's about 2.5 acres. So this would just be a pole barn for the storage of our yard equipment, boat, that type of thing.
All right, thank you. Board, any question for Ms. Johnson? Okay. Staff, anything else? All right. If no further questions, the Chair will now entertain a motion regarding item CU-2026-08. And with your motion, please state whether or not you adopt the staff's findings of fact as presented by staff, or for any reason you do not accept staff's findings, please go through all the criteria and address each one specifically as to why you do not concur with staff findings and provide substitute findings. Do we have a motion?
I'll make a motion that we accept the staff's recommendation.
Second.
Motion by Ross and second by JC. Any discussion, board? All right. All in favor? Right hand. Motion passes. All in favor.
Thank you.
All right, thank you. All right, our next case is number CU-2026-10, 200 block New Warrenton Road, a conditional use request to allow outdoor storage. Request by Meredith Bush, agent for ATI Properties of Pensacola, that's the owner. Any ex parte communications regarding this case, board members, any knowledge or information obtained from a site visit or other sources? Seeing none. If any board member intends to refrain from voting due to a voting conflict of interest. Yes, sir.
I don't need to recuse myself, but I do need to do a disclosure regarding this owner or this applicant, if I may, Mr. Chair.
Yes.
I wrote a statement because it's my first day here, so I want to make this correct. I do understand, I believe this is Asun Locks that is the applicant. So for the record, I want to disclose I do have a minor routine business relationship with the applicant's company. I use their services occasionally in the normal courses of my work. I do not have a financial interest in this applicant, or this application, and this relationship will not affect my ability to evaluate the case based solely on the evidence in the Land Development Code.
Madam Attorney.
I'm sorry, you said that you have an ongoing business relationship with the applicant?
It's a minor one. They rekey houses for me.
Okay, so you conduct business with the applicant?
Correct, they rekey. I don't believe that's going to allow me to, I'm not going to be biased on making that decision unless
I mean, it
I
sounds
need
like you're
to.
a customer of the applicant.
I am.
Yeah, so that's a conflict.
Okay.
And you're gonna need to fill out a form and abstain.
Sure. I will recuse and abstain.
Respectfully, my understanding of a conflict would simply be inure a benefit as though he were an owner or had an interest in it. I mean, staff supports our, position. I don't know that missing one vote's going to make a difference, but I would disagree that it's a conflict for a customer, and we're all customers of many businesses here in the county.
Well, I think having an ongoing business relationship of any kind could be a conflict.
I'll let them sort.
If, however, your client does not have a concern and you do not consider it a conflict and you do not believe it will have any bearing on your vote.
Well, from hearing you, I think to not muddy the record, I'm going to recuse myself.
Thank you.
Ms. Susan?
I also use this vendor. I've never spoken to them, never ordered services, but I know my employees have. I manage 700 properties in the area, and I know we've used them as a vendor in the past. But other than that, I don't have any other communication with this company, so I guess I'm going to defer to attorney.
Okay, if the nature of the relationship in either case is strictly that you may have been a customer at some time of this applicant, of the business, then I will leave it to your discretion as to whether you would consider yourself biased in any way if you were to participate in this.
I would not be biased, so I will continue to hear the case and
I won't either, but I don't want to muddy the record, so. I'm the
As I
same
said-
situation as she's in.
Well, then, I think if the applicant does not have any concerns, you've stated it's not going to have any.
I don't
bearing.
personally know him, I just use their company.
Okay, then, I think we're okay to proceed.
Yes, sir.
Ms. Bush, has there been any opposition to this request that you're aware of?
None. No, everything's been supportive. Staff supports our request. Just one point of clarification, when Mr. Chair did call the case, he referenced the next case of New Warrington. This is actually on Airport Boulevard. However, and that's just to clear up a misstatement. But no, everybody's been supportive, as indicated simply by the statements made already. They're a great reputation company here in the community. I've called them myself before representing them to assist with, when I was locked out of my house accidentally. So, I don't know that there's any concerns from anybody, but we're happy to present our findings.
Staff, and is it okay? I see what you're saying. I did move too far ahead to the next one. Is it okay for us to just take care of the next one or do we just start over from the next one? What's the proper way to do that?
I would just
Clarify.
reread your script
Okay.
for CU 2026-09.
Okay.
And I also wanted to clarify, so a conflict would arise if a person, you would have to abstain if a measure upon which you would vote would inure to your special private gain or loss, financial special private gain or loss. So, and it could be yours, it could be a relative, it could be a business associate. So that's the standard for determining whether you have a conflict.
And just one additional point on that, the actual conditional use here is to allow automobile sales at a site. They have a fleet of cars that go out. It's not anything to do with rekeying locks as far as this conditional use, and it sounds like both customers would use their locksmith service. So to the extent they may be, a more profitable business and be able to offer more locksmith services, I don't know again that that's going to affect the customer's interests.
And before we go farther on, I just want to state that so there's no confusion with the board or anyone else. We are on case number CU-2026-09. That's 129 Airport Boulevard, a conditional use request to allow automobile sales, requested by Meredith Bush, agent for Ace Unlocks of Pensacola, Inc.
Thank you.
Thank you.
Since I'm up here, I would just say we defer to staff's findings. They're fully supportive, even with the understanding that we will go through the development review committee process after this process, depending on the outcome. So.
Board, staff, anything else from staff?
No, if you like, staff, Caleb McCarty, AICP planner on behalf of the county. We found that it met all the criteria of the conditional use request, and we can expedite this request if the board would so have it. Contingent, we recommend approval contingent upon the completion of the development review process for site plan.
Board, any questions for staff? Any questions? Further questions for Ms. Meredith? All right. Well, at this time, the chair will entertain a motion regarding item CU-2026-09. And with your motion, please state whether or not you adopt the staff's findings of fact as presented by staff. If for any reason you do not accept staff's findings, please go through all the criteria and address each one specifically as to why you do not concur with staff's findings and provide substitute findings. Do we have a motion?
I'll motion to adopt staff findings as fact.
And we have a motion by JC, and do we have a second? We have a second by Mr. Travis High. All in favor, raise your right hand. Motion passes. All in favor. Thank you. All right. Now we at case number CU 2026-10, 200 block New Warrenton Road, a conditional use request to allow outdoor storage, requested by Meredith Bush, agent for ATI Properties of Pensacola. Board, any ex parte communications regarding this case, knowledge of or information obtained from a site visit or other sources? Anyone? No. Seeing none? Any board members intend on refraining from vote due to a voting conflict of interest? Right. Seeing none? Okay. With the individuals who are a party to this item, please come to the podium, state your name and address for the record so you can be sworn in by the clerk.
Meredith Bush, again, 314 South Bayland, Suite 108. This is another case that we can expedite. There's been no opposition. Staff is fully supportive. This is for outdoor storage of operable vehicles. It's basically a property across from Warrington Auto, which is owned by ATI Properties. They would use the lot to park overflow cars, overflow parking that are either waiting to be repaired or repaired, waiting to be picked up. It's obviously not a junkyard or salvage or anything like that. It's basically a parking lot, but it's outdoor storage because it's accessory to their existing automobile business.
Thank you. Any questions on board? All right, staff, any comments?
No, just to remind the board again, this is for outdoor storage. We found that it met all the criteria for the conditional use, contingent upon the completion of the development review, site plan review process. The applicants, in a conversation with them, they have already started that process with a pre-application. They'll need to put some screening and those type of things up. But of right now, we do recommend the conditional use as submitted.
Okay, thank you. Anything else from the board? Okay. The chair will now entertain a motion regarding item CU-2026-10. And with your motion, please state whether or not you adopt the staff's findings of fact as presented by staff. If for any reason you do not accept staff's findings, please go through all the criteria and address each specifically as to why you do not concur with staff findings and provide substitute findings. Do we have a motion?
I move that we accept staff's findings.
Motion by Ross. Do we have a second?
Second.
Second by Susan. All in favor? Motion passes. All in favor? And that's it for today for our cases. All right, discussion.
We have several cases next month. The next meeting will be Wednesday, March 18th at 8:30.
All right.
And it may be a long one.
Thanks, Doris.
Hey, we're glad to have our new board members today too. We're very glad because it hasn't been this full in a while. You know, it's been a while, and I want to encourage y'all to continue to come. Don't disappear on us because it's so important that our community gets represented fairly. You know, they don't. Sometimes I feel like they don't get fair representation when we don't show up. You know, and I've been sick before, and and had to be absent. But things happen. But I mean, we try our best to get in here and do what's right. And anything, Madam Attorney?
No, but with our new members particularly, I will in the near future, maybe on a meeting date when there aren't a tremendous number of cases, try to give you a public records review and sunshine law review.
Perfect.
I do got a question. We We have this all the time. We try to tell them, but I just don't know the legal terms to tell people. We have, if people want to appeal the BOA decision, it does not come before this board. It goes back to the circuit court. And many times they be asking, well, how can we help them? Can we do anything to help them to get that process started? And many of the citizens sometimes, well, can y'all help us? And I gotta go to circuit court. So could you help explain? I mean, what's the right term to tell them just to go to the circuit court? Because many times they be wanting information, we just don't have that insight like that.
Well, you could just point them to the provision in the Land Development Code that, provides a right of appeal. But I probably would not go so far as to offer any assistance with that.
Right, and we do not, and sometimes they just don't like that, then they get mad, but we tell them, we're not, you gotta. Yeah, call a lawyer. And do I gotta go? Yes, you gotta pay money for a lawyer, so it just, because that's what they were saying, I'm sorry, there's nothing I can do, we can't help you if you wanna appeal the BOA decisions.
Yes, sir, please do.
I also want to add from experience that you should not make any estimates as far as the time it takes, because it can take a long time.
It can take years, and it often does. Anytime, we don't have any pending at the moment, but I will always keep you advised when we have an appeal pending. But it happens periodically. And two, especially with our new members, if you suspect when you see an agenda that you may have any conflict of interest, I would ask that you please contact Rachel, and she can put you in touch with me, and we can talk it through, and I can, make an informed decision. It's difficult on the fly when I don't know the circumstances, and then I'm always going to err on the side of caution. But it's helpful if you can give some advance warning, and there is a form if you need to abstain that has to be filled out, and we can discuss that too. So.
A concern of mine has been, since I've been on the board, is attendance. And what could this board do to help attendance as far as we just had a board member that has been gone for quite a while. And, there was nothing, it seems like there was nothing just enforced. What could we do?
What I would just make a comment with that is that specific board member was commissioner appointed. So Horace and myself were in contact with that commissioner specifically, and that's why we have Travis now. With at-large members, they're only here for 2 years versus the commissioner ones, you follow your commissioner, and if a new commissioner comes, that will be appointed. Typically, I believe in the LDC, it says if you miss 4 meetings consecutively, your commissioner should be advised of that.
And once the commissioner is advised, what can be done to enforce that if they don't, do anything about it?
I don't think that's really the problem. It's finding somebody.
One of the duties assigned to county commissioners is the right to appoint who they see fit to boards. Those appointees are ratified through the BCC. We work for the administrator who works for the board. We can alert them to things, but we aren't bringing decisions in their direction.
Okay.
And ultimately, you reach a point where you can't maintain a quorum, and then it most certainly comes to light that there's an issue. But otherwise, with a particularly commissioner-appointed position, there is little that can be done until someone gets reappointed.
We have had that issues in the past where we didn't have a quorum, or we get in the awkward situation of having an even number and a split vote, which is always a denial for the applicant. So let's avoid those. if at all possible.
You know, I don't see that happening in the future, you know. I mean, I think we got a good team, you know, and, no, I just, you know, just in the future, for when we're not here, you know, I was just trying to find some type of preventative way, you know, to prevent that, because, you know, it's good just to have a quorum, but it's also good to have representation from each, district, you know, or at large seat, you know, is always good. And that's it. Anything else?
Mr. Chair, may I?
Yes, sir.
I thank you for allowing me to, you know, speak. I will not be here next month, not because I don't want to do this.
No.
So I just have a prior commitment prior to being appointed. So I won't be here next month, but I'm good after that.
No, it's fine. Things happen. I mean, things happen. We just had another situation, but we good. We good. If nothing else, this meeting is adjourned.
If you could pull up on the computer, that'd be good.
That's who he's replacing.